We have some genuine breaking news here. Judge Tanya Chutkan of the D.C. court has granted Donald Trump's request for a stay of all proceedings in his D.C. criminal case, writing that Trump's appeal on presidential immunity grounds has forced her hand. All pending deadlines and court dates in that case will be stayed but not vacated. This is about the appeal to the Supreme Court that Donald Trump has presidential immunity. Donald Trump didn't appeal to the Supreme Court, but Jack Smith did. The Supreme Court said, yes, it will considering it. It has asked Donald Trump's team to come up with a response to Jack Smith by next Wednesday, I believe, December 20th. And now Judge Chutkan is saying until the Supreme Court rules on this, she's going to put everything on hold. She's not vacating it. It's not getting thrown out, but she's going to put everything on hold. Back with us, MSNBC legal analyst Lisa Rubin. Did I get that right?
You did. And what I would say about this order, it's a very short opinion in order, Katie. It's 3 pages long, is Judge Chutkan is saying that the trial is stayed and pretrial proceedings like discovery and motion practice are stayed too.
As in they're just put on hold.
They're put on hold. Nothing that Donald Trump's lawyers would have to do affirmatively is anything that they have to do until the appeal is resolved. However, she is siding with Jack Smith's team on one important issue, and she's saying, look, I don't get divested of jurisdiction over everything. I can still enforce the gag order, enforce a protective order over discovery, meaning Trump's team can't release all the discovery they've received from the government into the public domain. She still gets to exert jurisdiction over that. And she's saying that I get to ensure that he meets his conditions of release. You'll remember that when he was first indicted, he agreed to be released with some conditions. Those include not further violating state, local, or federal law and not contacting any of the witnesses in this case about their testimony in this case. So to the extent that Donald Trump violates those conditions of release, Jack Smith and his team have every right to go back before Judge Chutkan and let her know.
All rules still apply. Everything is just on pause. I'm going to read you a little bit from her order. She says, if jurisdiction is returned to this court, as in if she gets it back, consistent with its duty to ensure both a speedy trial and fairness for all parties, consider at that time whether to retain or continue the dates of any still future deadlines and proceedings, including the trial scheduled for March 4th, 2024. So March 4th, 2024 still could happen, she's saying, right?
That's right.
If the Supreme Court comes back fairly quickly.
That's right. And, you know, right now, you and I discussed the other day, Jack Smith is sort of taking a two-tiered approach. He's asking both the D.C. Circuit to expedite its appeal and trying to go straight to the Supreme Court and leapfrog that D.C. Circuit. And they have agreed to expedite its consideration of whether to take the case. It's possible that they'll say, we're not going to take the case, but that the D.C. Circuit does and takes it on an expedited basis. So this is a little bit like a board game, right?
So we're talking about expedited basis. Let's talk about how expedited they actually are. If the D.C. Circuit has it, the Supreme Court says we're going to wait for them to take it. How quickly could they do this?
They could do this in a matter of weeks.
Do they do things quickly in the D.C. Circuit?
As a matter of course, generally no. So the appeal that we got back last week on the civil cases where Trump was asserting immunity, that took almost a year from argument to decision.
That's not quick.
It's not quick. However, that is a court known to move with alacrity when it chooses to, as does the Supreme Court. In the Nixon case, where the Supreme Court also granted this cert before judgment procedure, between the time of the district court decision and when the Supreme Court said, yes, the Watergate tapes have to be turned over, that's roughly an 8-week period. So, yes, we could still see a March 4th trial or slightly thereafter, but Judge Chutkan is not relinquishing that March 4th date because she wants to try this case as close to March 4th as she possibly can.